Okay, thank you for coming after the break. So now I'll open the floor for questions. If it's not too selfish of me, I would like to start the questions. Um, so David, you've touched on the principle of in city in apportionment of damages, and that principle always perplexed me a bit. So I would like to get your personal opinion on something. Is that apportionment of damages by implication means that there is a delay due to the employer and delay to the contractor at the completion date, and that's why the judge would say, okay, I'll apportion the damages. But to me, that seems contradictory to the contract itself. As you mentioned, under Scottish law and even under English law, the contract terms really govern, and the contract terms, there's always a procedure for claims. And so if there's a delay due to the employer, and assuming that the contractor had submitted a claim, so the contractor is entitled to an extension of time, and that would mean that we cannot hold the contractual completion date fixed and then say we'll apportion the damages. Actually, there should be an extension of time corresponding to the delay of the employer. So what's your take on that? I mean, to me, it's always this apportionment of damages thing gives me, problems conceptually.
Well, thank you for that. On City Inn, I have a very minor interest to declare, which is that the firm I worked for at the time were acting for City Inn. It was my boss who was the solicitor for the losing side. So institutionally within me, if you are saying Waleed, which is, I think, what you are saying very politely, do I think City Inn is wrong and a load of rubbish? Institutionally, from my old boss, the answer would be yes. In terms of, and my involvement in City Inn was that I spent half a day during the hearing on the facts, note-taking in the court. So I have that's my tiny piece of constructional history, is that I was very briefly involved in City Inn against Shepherd Construction. All of which is trying to buy me some time to answer the question. If you look at the judgment in City Inn, the judges are clear that they are taking a contractual approach and a contractual interpretation approach. That is their express state. They're not saying that fairness and reasonableness comes from somewhere other than the contract. So it may be the wrong approach, but they have grounded that decision in the contract itself. And what they look at is the fact that the assessment of the extension of time by the architect is done on a fair and reasonable basis. And they contrast that with the ascertainment of loss and expense, which is much more factual. So I think the argument the judge in City Inn made was that there is some discretion given to the architect over how they assess the extension of time, and they do so on a fair and reasonable basis. And therefore, if there's concurrent delay where there is a question over how much time should be given, then it is not unfair or unreasonable. They didn't quite use it that way, but essentially it's not unfair or unreasonable for the architect to not give the full extension of time allowed. It links quite closely in language to the contributory negligence type assessment. They use that point, but I don't think they really expand upon it in the judgment. But I think that's where it comes from. To that.
Okay. Yes, thank you. Go ahead. Microphone.
The prevention principle in general, it applies on a contractor. He missed the completion date. He missed the time for completion. He's asking for a reasonable time to complete his performance of obligation under the contract. But can we take the other party's viewpoint in terms of, if we talk about the bad faith or the good faith? Okay. So can an employer accuse or take the other view that the contractor participated or contributed to make the time at large, and therefore he cannot get advantage of his default? For example, the contractor, he did not ask for time extension after he missed the completion date for months, for many months, okay? And therefore he participated to mark the time for completion as at large.
I suppose the way they stood, and this maybe links into terms of good faith and bad faith, is that if there is the mechanism in the contract, then the contractor should use it, and if they don't use it, then that's not the employer's fault. One of the questions which I think is one of the questions which I think was probably outstanding, but I think Coulson in North Midland and Sidon has resolved, is what happens with the position where there's a condition precedent in the extension of time clause. So if you look at the NEC standard form, there is a time limit on when the change or the compensation event has to be notified. And I think there was some discussion about whether that would trigger the prevention principle, because there you would lose your right if you didn't notify the extension of time, so that would be prevention. And the contrast was always drawn with the JCT, because with the JCT standard form in the UK, they have a sweeper position that once the project is complete, you can essentially wash up any outstanding extension of time at the end, so that avoids the problem which is in NEC. I think because Coulson in North Midland and Sidon has said you can contract out of the prevention principle, I think if the clause was a condition precedent and was held to be sufficiently clear to meet those requirements, I think North Midland probably says that's okay. I don't think that's quite the question you're asking, but that's the answer I'm going to give.
Actually, I want to also add something, and I want to actually thank you for that question, because that was one of the questions, one of the comments I wanted to mention to you as well, is that because you mentioned the implied contract terms and the prevention principle, and because one of the papers that I had read as I was doing my research on time bars actually mentioned, say, the case where employer has clearly delayed the contractor. There's no doubt that the contractor, that's pure, say for example, a variation was issued at the end of the project, and this clearly delayed the project. But if there's in the contract a procedure, especially as David mentioned, a time bar procedure where the contractor has to notify within a number of days of a claim, and the contractor simply did not notify, and it was late. Hatta did not fulfill the exact time, despite that the delay is clearly on the employer. This author of that paper took on the position. I'm sure I think this is England and Wales, not Scotland. But what he was saying, and actually there's a lot of people that support that position, is that the contractor is not entitled to a time extension. But not only that, he's subjected to delay damages, and the reason for that is because, as in the words of that author, the contractor failed to operate the contractual machinery for requesting extension of time. So it goes back to so the default is in that argument is completely on the contractor, although the delay is purely from the employer. But that in that case, that argument you would apply damages and.
How can the sign of bad faith?
Well, your question, this is in a setting under Egyptian law or under English law? Egyptian law? No, if the contract is silent, then as David has shown in the slides, there is a provision in the civil code. I think it's, I don't know if it's 215 or 216, where if the الخطأ المشترك, يعني there's the employer contributed in the fault. So therefore, of course, by virtue of the Egyptian law, they can apply damages. However, these damages will go back to the contractor. So اشتراك في الخطأ, or contributing to the fault, in this case would be that the variation was issued, that the employer prevented the contractor for completing on time, which I think this actually is the prevention principle in play. But no, the contractor, you would not, as long as there is a variation, so you cannot really say, of course the employer in arbitration will mention the contractor was bad faith and all this stuff, but by virtue of that clause, the employer cannot benefit from his default. Yeah.
But the delay itself, the delay event itself, cannot be mediated by the employer. So the employer cannot allege that, okay, if you have notified me earlier, I could have done any kind of mitigation measure. Force majeure. In some contracts, force majeure events shall be notified. If a contractor delayed in notification of force majeure event, shall his extension of time entitlement be voided? In the case that there is no consent in the contract.
Is your question also Russian law or UK law?
Common law or
Okay.
English law.
Then I'll leave that to you.
Yes, the question is sometimes employers allege or say that if there is no condition precedent in the contract, however the contractor failed to time out extension of time event, but the delay event itself cannot. It's a must. So the employer cannot allege that if you notified me earlier, I could have evaded this or mitigated event. So anyway, the delay will happen and the project will be shall be extended. So case, I think the failure to notify shall not make the entitlement.
So I think that starts to get into one of the issues that one of the judges in the Duncanson case, which is the old Scottish case, looked about things around impossibility, which is where you start to think about ideas around force majeure and frustration. And I think that's probably the sort of situation which you would want some sort of equitable adjustment type rule, because you are getting to the stage where there is a material change of circumstances, and there would be an assessment about is the situation as it now arises what the parties contracted for. If it is one that and then I think Scots law generally, and I think English law too, although I haven't double checked this recently, is sets its face quite hard against those sort of changes to the terms of the contract. It says that the party it won't generally allow parties to recover where essentially it's an economic hardship that they are suffering as a result of the change of circumstances. It would have to be something physical, so it would have to be that the force majeure event is preventing the work from being completed. And then you may get into a question about whether the contract is brought to an end by those events or not. And if it's just a case of the contract has become significantly harder to complete, then that is just back into an interpretation of the contractual terms. And generally, I think the courts set their faces quite hard against it. So they would force the parties they would say, well, you've contracted for this performance, so this is the performance you have to deliver. And just because it's harder for you doesn't mean you don't have to deliver it.
I want to add something. Now, if we go to the Egyptian civil laws, first of all, when it comes to time bars, this is debatable under it's not even force majeure, even normal circumstances. It's for example, I mentioned the issue of good faith. Article 148 of the Civil Code, you have three key words. You have good faith, and you have actually four key words: good faith, law, equity, and usage, urf. So what do all these means? What do all these terms mean? We don't know exactly, but they run alongside the contract. They're exactly fee contract terms, and these are actually with the contract terms. So in the situation you mentioned, it would not be it would be contrary to equity, for example, adala, that the contractor has to notify of something that is event that is so general like that, when everyone it's well known. So it could be contrary to good faith that so all these things can trigger that, so that can render the notice not required. In addition to that, the Civil Code has a provision on force majeure, as well. That's it. In addition to that, the civil code has a provision on الحوادث الاستثنائية, which is different than force majeure, but I mean it's talking about an event that is completely unforeseeable, and so all these things to answer your question from the Egyptian law perspective, no, the notice would not necessarily be required. So that's just wanted to highlight.
If I could just add, the other thing is that although that position is quite harsh, I think that sort of position of being very harsh on changing circumstances is what those people who are proponents of this relational contract theory as set out in Bates and previous cases are seeking to mitigate. One of the leading voice in the English judiciary is Lord Justice Leggett, and he gave a lecture where he essentially said contracts need to be more flexible than we have traditionally allowed, and he sees, I think, good faith as the mechanism for that. So I think to the extent that the thing is changing in England, at least, it's the use of good faith to try and mitigate those and create that room for flexibility where it's necessary.
How can we apply if you have a hill or high water? If we have a hill or high water, hill, I mean a condition that we cannot be breached, a clause that must be done whatever the case.
So you've in the context of the prevention principle, you have something where it explicitly says, notwithstanding any notion of the prevention principle of the ruling Sterling against Maitland, this will not entitle you to an extension of time. I think that would be an interesting argument to run. It's a bit similar to one point I was thinking of making when Dr. Waleed was speaking just now, which is not quite as strong as that, but I think is a useful way to think about it. It was if your extension of time mechanism would be that the architect will assess the extension of time and then the contractor will be awarded half of that number, would that comply with the prevention principle or not? Because there would be an extension of time mechanism within the contract, and there would be an extension of time mechanism within the contract. It would simply be that you don't get an extension. I think probably the prevention principle seeks an adequate extension of time. So I don't think you could contract for less than was adequate. However, taking this implied terms approach, I think is, well, if the contract is clear that you've contracted out of it, then you've contracted out of it. And I suppose taking the contrary view would be the contractor should simply not sign up to that. I mean, that is where they are opening themselves up to a very, very significant risk, because they're not going to get any extra time or money if there's any sort of delay event.
But we have some conditions like that at the administrative contracts we have here in Egypt. I'm asking about.
Well, firstly, Dr. Waleed is the expert in Egyptian law, but I think if you were to try and argue that in a British court, you couldn't say you weren't aware that clause. If that clause was so clear in the terms I've set out, which is that notwithstanding this rule, this is the case, then the argument would be that you couldn't say you weren't aware that this is what was being done to you, and so you've accepted that as one of the risks. It would be the same as accepting something like a fitness for purpose obligation. It's not always a great idea in terms of your commercial risk management, but sometimes you just have to sign up, and what you should be doing is increasing your contract price to cover the necessary insurance and risk.
Just wanted to add also that there's two things to consider. First of all, as David mentioned, the issue of foreseeability. So when they signed the contract, did they know that there's this hill or there's this obstruction, or they did not know? This is something that appeared later on. That's the first question, because if they did know that there's this obstruction that is happening, then the contractor, as David mentioned, should have taken this into account in his risks. If they did not know, then that's a different issue. Assume that they did not know. The administrative contract is governed by administrative law, so Qanun 89 or the new Qanun, which I believe has a provision for force majeure anyway, and for unexpected events. So the contract in that case may run contrary to the law. In that case, the law will govern. So I think I'm not an expert really in administrative law, but I would consider this aspect, that there is the law and there is some rules that will govern these contract clauses. Okay.
time bar clauses are debatable here under the civil law jurisdiction. But I find it very confusing when one article in the civil law itself, it allows the contractor, or it denies the contractor his right to an entitlement to an extra money if the budget of the project is increased without notifying the employer within a very specific period of time. I think it's very confusing why the subject matter of the time bar is debatable, whereas the civil law itself allows for such a time bar.
That's a very, very good observation. Actually, in my PhD, I specifically mentioned this point. I personally think that this is a contradiction in the civil code. Remember, the civil code has been really written or published in 1948, but you actually have several contradictions. The first one is you have Article 147(1), which says that the contract is the law of the parties, which is the servanta. I always can't say it right, but the contract governs. Okay. The next article, it says, but there's good faith, and that almost contradicts with if you just say good faith and equity and adala and urf, that's almost saying we can throw the contract provisions can be changed almost. Yani. This article that you mentioned. It just says that in the case that in a remeasured contract that the quantities are increased by a very substantial amount, and the contractor does not notify and actually fil hal or immediately, not even 28 days, not 10 days, immediately the employer, then in that case that not only will the contract price not be increased, but the contract can be terminated, and all this stuff. There are some who would argue this is not a time bar because this is talking about purely BOQ, the quantities in a remeasured contract. It's not talking about a claim situation. Okay. I don't really agree with that. I think that you can extend that to the situation of a claim. So it's not just, of course, that runs contrary to what we understand of a remeasured contract anyway. However, I think that it fully applies to a situation where there's a variation, and yes, you're right. I think that actually supports the time bars in a contract, and I think that makes perfect sense because of Article 147, and also because that civil law is based on the Islamic law, and Islamic law, there's a lot of references that support that the contract terms are to be respected. So there is a debatable thing. What you just mentioned actually is a groundwork for a very good paper on research. Is that article specifically? And how that can support the issue of time bars. And by the way, this article is not just in the Egyptian civil law. It's in UAE civil law. It's in Qatar civil law. It's in Kuwait civil law. It's in Libyan civil law. It's everywhere. And I think we're not really addressing the situation. I think this is a very, very important observation.
I'm trying to search for any court decision that supports the application of a time bar clause, but unfortunately I didn't find any, except under the common law legal system there are plenty of cases.
I'm searching as well.
If we have a scenario here that is the contractual completion date has been elapsed and the contractor is in culpable delay, and there is something happened, let's say severe weather condition during that period, the engineer is entitled to say there is no extension of time for paying this supposed to be accrued but for the contractor delay.
So should the engineer be, when they're deciding this, is the engineer entitled to say there's no when there is concurrent delay, or just a contractor? What was the? Yeah. Yeah.
Okay. And the contract is in culpable delay.
Yeah.
Then there is severe weather condition, let's say, and the contractor submitted his claim to ask for extension of time.
Okay.
engineer or the architect is entitled to say there is no extension of time for being this was not supposed to be occur, but for the contractor delay?
Yeah, so that would be a concurrent delay type question, because you'd be saying there's culpable delay on the one hand and non-culpable delay or employer responsible delay on the other, and the engineer is then assessing the delay by trying to work out the impact on the critical path and saying, well, while there was contractor delay, on the one hand, it's not made up for by whether it's made up for by the weather. So that's the classic concurrent delay type situation, which is what happened in Sidon, where there was slow work by the contractor on some elements of the work, balanced against allegations of bad weather. I mean, it wasn't determined whether there was concurrent delay or not, because they said the contractual clause struck out the issue of concurrent delay altogether. So if you're looking to assess it as the engineer, you would now in the UK look at the test set out by John Marin of whether there was culpable, whether there was concurrent delay. So that's the first question: is does it meet the Marin test for concurrency? If it doesn't, then it's a question of which is the cause of that delay, and if there's some cause left over, then that would be the way that the delay is awarded.
The contractor was already in culpable delay. That means the contractor has already passed, and by the default of the contractor.
Mm-hmm.
And frankly, this weather condition, if it occurred during the working period, okay, he will do extension of time. But during his culpable delay, I'm sorry, this happened. This is attached to the contractor delay. For that, I was thinking that the engineer may say, no, there is no extension of time.
But the legal test is the test for what is the cause. What is the cause of the delay? Is the cause of the delay the culpability of the contractor, or is it the weather event?
Thank you.
I wanted to also add something because Amr raises an interesting point. When we mentioned the term contractors delay, okay, I think that my personal opinion is that courts and arbitrators and judges sometimes, I think, oversimplify this phrase. So what do they mean by? Is it really possible that you have 100% contractor delay after this project completion date? One thing a lot of I think employers, at least here in Egypt, and maybe you can also shed light on this in the UK. One thing that they miss is that there are employer-caused delays that may not be physical. So, for example, if a contractor submits a claim, and of course, Amr, we've went through this experience at work. Submits a claim, and it goes to the engineer. The engineer sends it to the employer. He has the assessment, sends it to the employer, and the employer sits on it. And so the contractor is waiting for a response to the claim. Wouldn't that be an employer's delay? I would say certainly it is an employer's delay, and it could be as strong as any other physical delay, because the contractor is waiting on this response and he's not getting a response, and this is affecting the productivity of the contractor on site. Had the contractor known when the completion date is, the contractor may have taken measures. So I think that's an effective delay, although that's not physical. That's purely, the claim. I'll give you another situation which happens a lot. Is the employer or the engineer orders extra work on site, but does not submit to the contractor a variation instruction or a change notice. So you have a site instruction that says implement this additional work with no acknowledgement that this is a variation. And so even if the contractor does not ask for compensation, even if the contractor is late in the notice, still that's an employer-initiated variation. You have prominent people. I'm sure you've all heard of Dr. Nail Bunni, a superstar in the FIDIC contracts. So Dr. Nail, who actually wrote, was contributing in the drafting of the FIDIC 1999 contracts, for example, is of the opinion that when you have a variation that is initiated by the engineer, that's not subject to the notice at all. The notice applies when a contractor is asking for a variation. But if a variation is being issued clearly from an instruction for a variation by the employer, then actually the burden is on the employer to issue a change instruction and possibly to inform the contractor of the time. So if a change is issued through a site instruction, through a letter, and nothing is done with the procedures of the variation, and the contractor is in the dark progressing on site, not knowing when the completion date is, that is an employer's delay. So actually in that case you mentioned, if that happened before the completion date, I would argue that the employer is in delay, employer is in culpable delay, and this situation of the weather condition is partly because of the contractor and the employer. Because had the employer issued the variation order in time, the contractor would have known when the completion date, at least in the engineer's opinion, is. The contractor may have taken measures to expedite progress and achieve this completion date. Even if not achieving this completion date, maybe reaching a completion date, completing the work shortly after that completion date, and not having to experience this weather conditions. So the consequences of the employer's actions, I think, is something that is missed and that should be factored into when we talk about employer's delay or a contractor's culpable delay. But this is just wanted to.
Thanks a lot for your answer, but may I add two
Sure.
sentences?
Go ahead.
The first one, the part that you speak about, Dr. Nail al-Bunni, it's already mitigated currently under the FITIC 2017. They speak that now it is the engineer instruction which is changed to be under subclauses. If this instruction has not like a CVI or something like that, it can say, I'm not going to do it until you say that it is instruction and it make a variation. Okay, that's part. The other part, when you speak about when the engineer is delayed his response or choose to apply the silent strategy or something like that, if the contract has a condition concerning the arbitration notes and notes of satisfaction concerning the time, maybe here there is no time at large, for being that he has a right already to send notes to of satisfaction and go to the DAB or arbitration or something like that.
Actually, I wanted to just make a comment before the next second question. I think, David, it's very interesting that you mentioned this issue of contracting out of concurrent delays. I was in a conference in the US and just a few in the summer of 2019. One of the things that was mentioned, actually interestingly, is that there's a recent trend that of contracting out of concurrency. So you have a contract clause that says, in the case of concurrent delays, the contractor is not entitled, for example, to an extension of time, which is, it's contrary, of course, to equity and all this stuff, and even common sense construction practice. But it's a trend in the US, and when you mentioned that, it almost struck me that is it a recent trend in the UK as well, or what do you think?
I'm aware around City Inn that it's one of those, it becomes an issue because everyone's talking about it, and I think people will see that as a risk, and it's a complicated situation, as you've mentioned, so people try and then contract in a way that avoids that risk. And I think it has been happening since at least City Inn. And I think in particular because, maybe less so now we've had North Midland, but when there was a difference of approach between Scotland and England, you're then, within the whole UK jurisdiction, you're considering there may be a situation where it's very obvious if you work in the UK that there are two different ways that a concurrent delay dispute could be resolved. So let's avoid that discussion altogether by contracting out of it. And so certainly, at least since City Inn, I've been aware that this has been put in, and I suspect part of the thing why it hasn't really flared up is that concurrency is understood so narrowly that I think the judges will try not to find concurrency. They will try and find, for example, in your situation, that one party or the other is. Yes. So, and that will come down to, I think where some of the points you've made, Waleed, about employer delays, I think if it's obvious the employer has not been working efficiently, then that is likely to weigh in the decision maker's head when they're assessing what is the cause of this delay. Yeah.
Any other question?
I have noticed a difference in definition between Lyson, Lyson and Jackson. I mean, Jackson is saying that prevention principle can come from a legitimate act. I can't get this idea. I mean, I'm more maybe in Lyson's position. I mean, a prevention act or act of prevention shall be, come from a statutory act or a contract, breach the contract. But if I'm doing the normal course of action, why shall be liable for any damages?
I think what he had in mind there, and I think the point again that Waleed's just made about the employer operating slowly. The employer may be entitled under the terms of the contract to operate slowly because they might be complying with the timescales, but that may still be slowing things down. So there's a bit of that. I think probably what he most clearly had in mind was a variation instruction, because an employer is entitled to instruct a variation whenever that's entirely within the bounds of the employer's contractual role. But a variation would trigger the prevention principle, even though it's perfectly legitimate. And I think the other areas are these sort of passive prevention, where there's a weather event or something, where you have to say essentially the employer's breach there is not indulging the fact that there's been something which has slowed the contractor down. But that's not a legitimate act by the employer. It's not a wrongful act by the employer. It's just something that happens. So the passive prevention, I think, also covers these issues about weather events, which are very conventional. And that all is against at least what rhetorically Lewison is saying, which seems to be that Lewison seems to be seeing much more to what your gut feel would be as to what would be a prevention act, which is something that actively prevents somebody from completing. But the Jackson and what I think is probably the construction industry approach is that slightly wider, slightly less clearly morally defined quality, which is where it's something that stops the contractor from completing.
Actually, I noticed also that regarding this legitimate act, we have a interesting article also in the Egyptian Civil Code that is addressing if someone is doing his legitimate act, but only for to party. I think there is some article like this. In this case, his act is not admissible, but it has to be established that this act is only for to cause damage to other party. I think this may.
This is Article 5. الاستخدام غير المشروع الاستخدام غير unlawful exercise of right. There are three factors. One of them is intention to cause harm. Another is proportion. Is the proportion of the benefit to the applying this, for example, time bar or this right, is the other party going to be harmed, for example, out of proportion? So a contractor is late for 5 days in the notice, but the contractor is the claim is for £1 million. So is losing £1 million out of proportion to the 5 days that was late for giving the notice. In that case, that's an unlawful exercise of the right, and therefore, that's a mandatory civil law provision, and that's one of the things that can defeat a time bar. There was another, also third factor, but yes, it's one of the things that can defeat a time bar as well. We are actually approaching. We have passed the completion date of the seminar. So if there's any questions, we can just take one more question, and we'll. And there are no time extensions. Okay.
Good evening. I have a sample, and maybe this is a tricky question, and especially for the engineer, not for the good faith term. Is it applied for the qualification and quantification of a claim? If you got my question.
Talking about the contractor in specific.
Let's say that the lawyer and the contractor, they agreed that he is for a claim, right? but he has limitations. So he cannot make that quantification for his claim.
Actually, it's not even good faith. It's actually, even if you go by the FIDIC contract, just hatta the terms of the FIDIC contract, which is not really written in a civil law background, because this is, in my opinion, this is one of the areas where employers abuse their rights. They tell you, okay, so the contractor could not substantiate the claim, so khalas, you're not entitled, or you're entitled to. But actually, what the FIDIC contract says, and I'm using FIDIC as an example, but most contracts are that way. Khalas, the contractor could not substantiate, then the burden is on the engineer to provide a reasonable value of this assessment. So it doesn't get the engineer or the employer off the hook. They have to still provide a reasonable value. How reasonable it is, this would be up to the arbitrator or the judge to decide. And the direct answer to your question is, even say there is no contract, there is no FIDIC, whatever, Article 148 says that all contracts will be are subject to good faith and subject to the law, subject to equity, al-adala, subject to usage or al-urf. So for example, if it is known that this kind of additional work by urf or custom in the industry costs X, not less than X. So khalas, then actually by even the law, by that article, which is the article of good faith, yani khalas, this is something that the contractor is entitled to, notwithstanding the issue of substantiation or not substantiation, you know. So I think that's my take on it. I want to thank you all very much for your wonderful audience. There was great questions, and David, thank you very much for this seminar.
No, thank you for having me, and it's been an honor and a privilege to speak to you all. And I didn't realize I was going to be sitting next to my own face in this way, but my contact details are there, so please do drop me a line if you've got any further questions or comments, and hopefully see you next time.